distinguished organizers, esteemed colleagues, and honored guests of the third CHMK National Forum for Media Reform, it's a profound privilege to address this distinguished gathering convened at Goldsmith, University of London. I would like to express my deepest gratitude to the Kurdish Media Watchdog, the Vision Agency for International Development, and the Kanga Education Foundation for this honorable invitation. I am an Egyptian judge, PhD holder from Cairo University in Media Regulations, Artificial Intelligence, and Cybercrimes, member at the International Association of Cybercrime Prevention in France, the International Association of Mediators and Poly Experts in Georgia, associate at the African Center of Cybercrime Prevention in South Africa, international expert at the International Federation of Neuro Legal Sciences in Mexico, and a legal expert in the Information and Decision Support Center of the Egyptian Council of Ministers, beside being an expert author in law and technology with Springer Nature. Although official academic commitments at Autonomia di Barcelona University prevent me from joining you in person today, I am so grateful for this virtual platform to share my judicial and academic perspective on a matter of definitive global importance, reforming media regulation, cybersecurity, and data privacy laws. Excellences, current technological advancements have radically transformed the methodologies of communication, catalyzing an unprecedented media and information revolution. This evolution has unlocked immense potential for human connectivity, effortlessly exceeding the conventional boundaries of time and space. And this modern reality is what is known as the digital media. While digital media shares foundational principles with traditional journalism, it fundamentally diverges by integrated disparate traditional communication tools into a singular, unified medium powered by the internet. Crucially, it amplifies public interactivity, transforming the audience from passive recipients into active partners and co-creators of content. However, this systematic shift poses severe challenges. Chief among them, the complete absence of regulatory oversight, the alarming proliferation of unverified data, and systematic threats to national security. Consequently, from a judicial standpoint, we can observe that while traditional media leans objectivity towards institutional neutrality, digital media inherently gravitates towards subjective personalization. With the massive expansion of digital platforms, the individual have become increasingly shackled by their own digital footprints, which continuously track and aggregate sensitive personal data. This leaves users highly vulnerable to unauthorized breaches and systematic exploitation. As a judge, I must emphasize that the media crimes are legally characterized as crimes by publicity. This entails making information available to the public indiscriminately through print, audio, visual, or digital media, executed via speech, gestures, writing, or explicit deceptions. Furthermore, these offenses constitute continuous crimes. The most defining characteristics of these complementary infrastructures is the transnational nature. These crimes easily cross sovereign jurisdictions, which imperatively demand robust, swift, and highly sophisticated international judicial cooperation to suppress cybercrimes and prosecute perpetrators across these borders. The formidable capabilities of artificial intelligence have accelerated the developing of augmented and virtual realities, while systematically enabling the mapping, tracking, and manipulation of the user behavior through algorithmic bias and social engineering methodologies. We are now witnessing a surge in sophisticated cyber threats, from user identity tracking, invasive cookies, and metadata exploitation to severe offenses like digital defamation, cyber blackmail, online sexual harassments, and deepfakes. The threats extend across the dark horizons of the Internet of Things espionage, the vulnerabilities of the metaverse, and the unchecked deployment of generative AI models like ChatGPT, Gemini, and more. Distinguished colleagues, information is the current power. Data grants the power to those who possess it, and big data yields absolute power. Legally speaking, history proves that every form of absolute power is inherently susceptible of catastrophic abuse. Let us unveil a crucial truth. The privacy assures on platforms like App Store or Google Play are false. In reality, modern applications systematically extract user data, map behavior preferences, and these intelligence for commercial purposes, an opaque phenomenon, legal term of the black box of artificial intelligence. Furthermore, leaving a personal account publicly accessible, whether intentionally or even by or through the lack of unawareness, is legally interpreted as explicit consent to public inspection. From a judicial standpoint, once data is exploited to the public, it cannot be longer classified as private, effectively stripping the individuals of essential legal protections. In light of these pressing challenges and to assist in the modernization of the digital and the media ecosystem in the transitioning regions like Kurdistan region of Iraq, I submit the following actionable legislative and judicial recommendations to be integrated into your strategic policy roadmap. First, enacting of independent digital media legislation. There is an urgent necessity to draft and enact a standalone dedicated regulatory framework specialized designing for the digital media rather than attempting to stretch antiquated traditional press laws to fit the digital age challenges. Number two, activation of the specialized data protection authorities. Number three, accession to the international treaties. Sovereign nations and regions must actively pursue accessions to the Budapest Convention on Cybercrimes, the UN Convention Against Cybercrimes, and this is essential to the international judicial cooperation, facilitates the lawful extradition of cybercriminals, and streamlines the cross-border exchange of digital forensics and electronic evidence. Number four, the legislation for the freedom of information flow. We must advance comprehensive freedom of information laws. These statutes are crucial to establishing a precise legal harmony between three competent interests: the constitutional right of the individuals to preserve digital freedom of speech and expression, the democratic right of the media to publish and broadcast, and the sovereign right of the executive to safeguard national security. Number five, the formulation of an adaptive cyber legal strategy. We must design a flexible, secure media legal framework. This requires codifying dynamic cyber laws that clearly classifying emerging offenses and mode social engineering tactics. Distinguished colleagues, the intersection of law, technology, and media will dedicate the stability of our future societies. By erecting robust legal framework, we do not stifle innovation, rather we protect human dignity. I trust that these platforms will serve as a valuable cornerstone for your strategic policy roadmap. Thank you again for this profound honor, and I wish the third CHMK National Forum for Media Reform absolute and transformative success. Goodbye.